Good morning, everyone, and welcome to Pension Law 2021. I'm going to share the presentation on the screen in just a moment. Please let me know if you can see my screen.
Yes, we can.
Thank you. So, welcome everyone. My name is Andrew Mutibi, and I'll be taking you through this pension law webinar, where we'll be going through two topics over 2 days. The first one will be divorce orders, and the second one on day 2 will be the distribution of death benefits payable by pension funds. So before we get into the presentation, I got accustomed to doing these presentations face to face. So, now we are doing remote work, and we're doing webinars instead of seminars. So just a few housekeeping rules before we start. Please ensure that your microphone is muted throughout the webinar. Background noises are distracting at times, and you may need to take a call or make a call or do something else. So please keep your mic muted. Because I'll be presenting, and as I share the presentation, I won't be able to see hands. So we also won't be following the normal meeting etiquette where people raise their hand on Teams. So what I'd like you to do is that if you have a question at any point, or if you want to come in with a comment, or perhaps you want to just engage, maybe disagree with something that I'm saying, then please feel free to do that. Please don't keep your questions until the end. I'd like this to be an engaging session. I'd like us to connect, to interact, and have this as a dialogue and not a monologue. So please do stop me at any point in time. We have the time. I will manage the time for us. So please, if you have any question or comment, please stop me at any point in time. Just unmute yourself and perhaps start by just saying your name so that I know who I'm talking to. And then I'll stop and you can come in with your question or your comment. But for the rest of the time, please keep your mic off so that there's no distraction or interference. Please ensure that your network is stable. Please also switch off your camera. We will be recording. We are recording this session. So, I hope no one has any protest or objection to that. And we will not be making the recording available after the webinar. So if you need to make any notes, please do that for yourself as we go through the presentation. Yeah, I think outside of that, we hope that you enjoy the session. We hope that, the session is valuable for you. We try to keep this as high level and yet technically detailed as possible. And yeah, we welcome any interaction, any questions that you may have for the session. It benefits everyone. Sometimes I know that people prefer to, have a chat on the side. But I think if you have a question or anything like that, it will benefit everyone that we interact all together as a group. Please don't forget to complete the evaluation form at the end of the session. It'll take just a few minutes. We need that. It helps us, the lead team, to improve the sessions that we present to our audience, and to also improve the quality. There's always room for improvement, so any constructive criticism is always welcome. There'll be certificates uploaded on the eLeader platform with instructions on how to print them after the webinar. So please do collect your attendance certificates at the end of the presentation. So without any further ado, let's get straight into it. So just to show you in terms of the contents of the presentation, day one, which is today, we'll cover divorce orders. We'll touch on an introduction to pension funds, just high level for the benefit of the people who still struggle with understanding, the different types of retirement funds that are out there. We'll touch on the protection of fund benefits, and then we'll get into divorce orders, and we'll close off with some frequently asked questions. And on day two, tomorrow, we'll be dealing with the distribution of death benefits payable by pension funds. We'll look at the different types of death benefits, the exclusion of death benefits from a deceased member's estate, and the 6 scenarios applicable under Section 37C of the Pension Funds Act. And then we'll look at the distribution in terms of Section 37C, and we'll close off with some frequently asked questions. So starting off with an introduction to pension funds. So people often use the term pension fund as a generic term. So a pension fund could be a provident fund, or it may be a retirement annuity fund, right? Or even a preservation fund. So in fact, with the legislative amendments that are proposed, that are coming up, there is a proposal to change the Pension Funds Act from being called the Pension Funds Act to being the Retirement Funds Act. And that is because, more technically correct would be, to refer to, using the term generically, it would be more technically correct to refer to a retirement fund as opposed to a pension fund. Because while pension fund is used as a generic term, it is also, a pension fund is also a specific type of a retirement fund. So we have pension funds, we have provident funds, retirement annuity funds, and preservation funds. So a pension fund is a retirement fund set up by an employer for its employees. So because there is that employer-employee relationship, pension funds and provident funds are often referred to also as occupational funds, because the member attains membership of the fund by virtue of his or her employment with that employer which participates in the fund. So with pension funds, what happens is that upon retirement of the member cannot just take the full retirement benefit as a lump sum. If that lump sum or the retirement benefit is 247,500 Rand or more. So if it's less than 247,500, then the member may take that retirement benefit as a lump sum in cash. But if it's 247,500 or more, then you may not take the full amount in cash. Now, what happens in that case is that you may only take 1/3, up to 1/3 in cash. You don't have to, But if you want to, you may access up to 1/3 in cash as a lump sum, and then the remaining portion will be used to provide a pension to the member. Now, before 1 March 2021, for members of provident funds, what used to happen is that irrespective of the value of your total retirement benefit, the member could take the full amount as a lump sum. So even if you had 10 million rand in the provident fund as your full retirement benefit by the time you retire, you could take that full amount in cash. So what happened over the years is that a lot of articles were written, reports in the media were issued about people who retired from provident funds and then decided to take the full retirement benefit as a lump sum, and those people then lost that money.
Sorry to interject, Mr. Mutibi, Karabo here.
Yes, Karabo.
It seems like we are still on the first slide. We are not where you are in terms of the slides.
Oh, are you not seeing the slide with the title Divorce Orders, Introduction to Pension Funds?
Are we still at the first slide?
No, this is not the first slide. My apologies for that. Let me perhaps I should unshare and then start sharing again. Thank you for bringing that to my notice, Karabo.
All right, thank you.
Let me stop sharing. And then I'll start sharing again. Can you see my screen?
Yes, we can.
Yes.
Is it on full screen mode?
On my side, it is, yeah.
Okay, thank you. Can I just move one slide and just to check if you are still with me? Are you seeing the second screen now, the second slide, the next slide actually?
No, we're still on the same slide.
Still on the same slide.
It's not moving, no.
And it's not in full screen.
And it's not on full screen. Okay, I'm not sure what the problem is. I apologize for that. I'm just going to try a different way of sharing now. I'll share my entire screen. Hopefully that helps. Can you see my screen? I'm on full screen mode now. Can you see my screen?
Yes.
Yes, now it's perfect.
Okay.
Yes.
Can I just move 2 slides to see if... Can you see the next slide?
Yes.
Yes.
And the clean break principle.
Yes.
Yes.
Thank you. Please do let me know if that happens again. I hope it doesn't happen again. All right, so I'll just continue from where I was. So we were now talking about provident funds, right? And I was explaining that prior to 1 March 2021, a member of a provident fund could take the full retirement benefit in cash, irrespective of the value of your retirement benefit. So if you are a member of a defined contribution fund, throughout your membership of the fund while you're employed, you are putting money into that provident fund. So each month, as you receive your remuneration as an employee, the employer deducts a portion and pays that into the fund. Now, that money accumulates over time with interest, and by the time you retire, that is your pot. That's what's available for you to receive as a retirement benefit. Now, some people used to elect to take that full amount as a lump sum and say, you know, I don't mind the tax consequences, the money may be taxed, but paid into my bank account. I will decide what I do with that money. Now, in some of those instances, what you would find is that those people then lose that money. You know, there are so many scammers and con artists out there these days. One story in particular that I recall is about a woman in Pretoria who received around 2 million rand as a retirement benefit. And she took that money to someone who claimed that he could triple whatever cash that you bring to them in an instant, just like that. So she and her husband first took about 20,000 rand to that person, and that person did his thing, and he, you know, magically made 20,000 rand turn into 60,000 rand. Now his deal was that you bring an amount of cash to me as a lump sum, I triple it and I keep 1/3 of it. So they went there with 20,000 rand. He turned it into 60. He kept 20. They walked away with 40,000 rand. So now they were convinced that this person is legit. You know, whatever he's doing actually works. And somehow they managed to withdraw that full retirement benefit, something in the regions of 2 million rand, and took that to him with the hope that he would turn 2 million into 6 million. And needless to say, they lost their money. So the government is also monitoring these things, you know, and National Treasury then decided that, you know what, it's probably better to try and protect people from themselves and, excuse me, harmonize the rules that apply to pension funds, you know, to provident funds. So with effect from 1 March 2021, the Income Tax Act was changed to apply the same rules which apply to pension funds to provident funds. Meaning that from 1 March 2021, if a person is a member of a provident fund, when they retire, they don't get to take the full retirement benefit in cash or as a lump sum, meaning that such a member would have to, you know, if the benefit is 247,500 or more, they would have to at least purchase an annuity or receive a pension from 2/3 portion of that retirement benefit. So those members can only access up to 1/3 in the same manner that, you know, it applies for pension funds. So prior to 1 March 2021, there was a notable difference between a pension and a provident fund. But from 1 March 2021 going forward, there isn't really any difference anymore. Now, I'm not going to go into detail about the other types of pension funds, but just for your information, I can mention that we also have what we call retirement annuity funds. They operate in a manner that's similar to a pension fund. The only difference is that with a retirement annuity fund, the member does not attain membership by virtue of employment with an employer. So you can get a retirement annuity fund in your personal capacity. Oh, I thought there was a question. So you can get a retirement annuity fund in your personal capacity. You can speak to a financial advisor. Normally they are linked to insurers, and you can then get your retirement annuity fund policy. Those retirement annuity funds were actually created for people who are self-employed, because in that case, you don't have a formal employment arrangement where an employer can give you membership of a pension or provident fund. When the member retires, the same rules which apply to pension funds also apply to a retirement annuity fund. So we look at the value of your fund benefit, your retirement benefit, and if it's 247,500 or more, then you cannot take the full amount in cash. You can only access up to 1/3, and the remaining 2/3 must provide a pension for you. We also have preservation funds, and how those work is that we have a pension preservation fund and a provident preservation fund. Now, the rules of those funds are linked to pension and provident funds, meaning that before 1 March 2021, if you had a benefit in a provident preservation fund, when you retire, you could take the full amount in cash, but from 1 March 2021, it's now aligned to pension funds. So normally preservation funds, are funds so they are created for people who are leaving a pension or provident fund to take their benefit from that pension or provident fund, because you are leaving before retirement age. You're still young, you're still able to work, and you still need to save for your retirement. Then you can transfer your money into a preservation fund. So it just holds your money, and they apply investment return over time. And by the time you get to retirement age, you receive a retirement benefit from a preservation fund. So no ongoing contributions are payable into a preservation fund. You only take a lump sum benefit from a pension or provident fund and transfer that into a preservation fund. It's something that's also used in divorce cases, because if the non-member spouse does not want to take that fund benefit that they are receiving, as a result of the divorce, if they don't want to take that and use it immediately, then the non-member spouse has the option to transfer that money into a preservation fund. So if there are no questions around that, I'll move on to the protection of fund benefits. So this is particularly important as a starting position, right? Because now this talks to the general principle. The general principle is that fund benefits are protected. They may not be ceded, they may not be transferred, they may not even be reduced. So when you look at Section 37A(1) of the Pension Funds Act, it provides that with the exception of the provisions of the Pension Funds Act itself, the Income Tax Act and the Maintenance Act, retirement fund benefits are protected from being reduced, transferred, ceded, pledged, hypothecated, attached, or subjected to execution by order of court. Now, this same section has also been interpreted in terms of case law to prohibit third-party payments, meaning that a retirement fund cannot pay a benefit due to a member or to a beneficiary to a third party. So what is particularly important about 37A is that this is the golden rule. The general rule is that fund benefits are protected, but with exception of the provisions of the Pension Funds Act itself. Now, when we speak about divorce orders, we have to look at Section 37D of the Pension Funds Act, and that is where you find the exception to the general rule. So we'll get to that as we go through the presentation, but I just wanted to start here by helping you understand that as a general rule, fund benefits are protected. When a retirement fund pays a claim for pension interest because the member got divorced. That is an exception and not the norm. The norm is that the benefit is protected and it is to be paid only to the member and not to any other third party. But while we're on 37A of the Pension Funds Act, I think it's also important that I bring to your attention that Section 37A4, so 37A subsection 4 provides that if a member or a beneficiary provides satisfactory proof that they cannot open a bank account, then the trustees may direct that the benefit should be paid to a third party. Now, the effect of that in practice is that, you know, a lot of retirement funds face this problem where there are people who are illegal immigrants. They came into the country, they got employed, they became a member of a pension or provident fund, and, you know, many years later, the member now has resigned or has been dismissed or is retiring, in some cases, even in death. So something has happened to trigger payment of a fund benefit by the retirement fund. And at that point, you find that it's only then that the fund becomes aware that the member is actually an illegal immigrant. Now, that also means that the member cannot open a bank account, or the beneficiary cannot open a bank account. I think about 5 years ago, we had a problem in South Africa where people who are citizens of South Africa, South Africans, could not obtain their IDs from the Department of Home Affairs. Some had applied and it had been years since they applied, and for some reason they could not get their IDs. Now, without an ID, you cannot open a bank account. And it is for that reason that in 2014, so with effect from 28 February 2014, the Pension Funds Act was amended and subsection 4 was inserted to section 37A. And that is this new relaxed approach. You know, it's the exception to the general rule that we can't make a third-party payment, to say if you provide satisfactory proof that you cannot open a bank account, then the retirement fund may make a third-party payment. So while we're on the subject of the protection of fund benefits, it's also important to look at Section 37B of the Pension Funds Act, which provides that if the estate of any person entitled to a benefit is sequestrated or surrendered, then their fund benefit will not form part of their insolvent estate. So once again, you're seeing how 37A and 37B work to protect retirement fund benefits. It's also meant to protect retirement fund benefits from a member's creditors. So if a person owes a retail store and, you know, the store takes judgment against that person, you know, or it's any other judgment sounding in money because perhaps it's a claim that was based on delict, you cannot present that court order to the fund to say, I know that you hold money on behalf of this person, he is the judgment debtor, therefore I'm attaching a portion of his fund benefit. I'm executing a writ against his fund benefit. So that cannot happen. And it cannot happen because of this protection, which we find in Section 37A and Section 37B of the Pension Funds Act. So I'll move on now to the clean break principle. So people don't speak of the clean break principle much these days, and that is because it's been a while since it came into effect. But it is important to understand the background, to understand where we come from and how we got to where we are. So before 13 September 2007, a non-member spouse who was awarded a portion of the member's pension interest in terms of a divorce order could not take a copy of that divorce order and say to the fund, here's my divorce order. In terms of this order, I've been awarded 50% of the pension interest. Therefore, pay me now. I need this money. I have things that I want to do. So what happened at that point, prior to 13 September 2007, is that the non-member spouse would have to wait for an exit event. And you still see, I know lawyers like using templates. You'll see that in some of the divorce orders that are drafted by lawyers, you find wording that says something to the effect of that the portion awarded to the non-member spouse shall be paid to the non-member spouse whenever the benefits of the member become due and payable to him. So it was along those lines, and with that understanding that the divorce claim would be processed prior to 13 September 2007. But then the legislature realized that, according to the payment of these divorce claims, the non-member spouse does not receive any interest or growth on the portion that has been awarded to him or her. So if the divorce order says that you're entitled to 50% of the pension interest, it is to be calculated as at the date of divorce, and that is what you receive, nothing more. So even if you submit that divorce order and you leave it with the fund for a year or two, you wouldn't receive any growth over that period. Now, it didn't make sense. It didn't make sense that you have to wait until someone resigns or gets dismissed or dies. And in some cases, some people stay with the same employer up until retirement. So if you get divorced and you're 30, you would wait until, he retires at age 65. And that didn't make sense. So the clean break principle was introduced by amendment to the Pension Funds Act, and that took effect from 13 September 2007, meaning that from that date, a non-member spouse who has a divorce order, which provides that they are entitled to a portion of the member's pension interest, could go to the fund and claim immediate payment of that divorce benefit. I say immediate payment, but it doesn't mean it gets paid immediately. There are provisions within Section 37D of the Pension Funds Act, which talk about how these divorce claims must be processed by pension funds. So a timeline is set out in Section 37D to say that a retirement fund that gets presented with a divorce order has 45 days to consider whether the divorce order is binding or not. And once the fund has decided that the order is enforceable against it, that it's a valid order, then the fund must ask the non-member spouse to elect how they want to receive that divorce benefit. So that divorce benefit may be paid as a lump sum directly to the non-member spouse, or it may be transferred to another retirement fund on their behalf. I mentioned earlier that we have preservation funds, which present that option where the non-member spouse can decide that he or she doesn't want to receive the money immediately. So instead, they can transfer that money into a preservation fund. So the fund gets 45 days to decide if it's enforceable. And once it's made that decision, the fund must ask the non-member spouse to make a decision on how it should be paid. And the non-member spouse has 120 days to make that decision. Once the non-member spouse makes the decision or election in terms of payment, then the pension fund or the retirement fund has 60 days to make the payment. So it's only in instances where the retirement fund delays in making payment and they pay that benefit outside of the 60-day period that the non-member spouse may be entitled to some interest. So the ordinary rule is that a non-member spouse is not entitled to any interest or growth. So while I'm on this point, I'd like to urge you as the legal practitioners, as the attorneys who are assisting parties and drafting settlement agreements and draft orders, that you try and steer away from that wording that talks about, how, within how long should the benefit be paid. And that is because that is something that will apply by operation of law. Because the legislation is clear, because Section 37D of the Pension Funds Act already prescribes how that should be paid, it's better not to try and deal with it in that settlement agreement or draft order. Just in case you don't get it right. I've seen some retirement funds reject an order on the basis that that provision is inconsistent with what's set out in Section 37D. So now you have to go back and amend your order because of a small, little technical issue. I thought I heard someone trying to come in with a question or a comment. All right, I'll move on then.
Andrew, sorry to interrupt. I see there's a hand up from Albert Murray. My apologies for interrupting.
No problem. Thank you for helping with that. Is it Albert?
Yes, it's Albert, Mr. Motibe. Are you able to hear me?
Yes, I can hear you. Yes, I can hear you. Please go for it.
On your slide,
but zingenile ilantuka in return of services.
okay, Mr. Motibe, on your slide, it says a pension interest. And I just want to understand, is this now in the normal sense of the word, you have an investment that has a capital amount and then interest is earned on it in terms of market movement, or does this pension interest simply refer to the fact that if you are married in community of property 50-50, you are entitled to 50% of the value, quote unquote, of the amount in the fund?
Okay, thank you for that question, Albert. That's a good question. It's a good question because there's a lot of confusion around this particular concept. So I'm going to touch on it in the next few slides, but I don't want to defer the question. I'd like to deal with it now. So pension interest is something that is specifically defined in the Divorce Act, right? So in Section 1 of the Divorce Act, you find two paragraphs that refer to the definition of pension interest. And the first paragraph applies to a pension fund and a provident fund. The second paragraph applies to a retirement annuity fund, right? Now let's move off the premise that we're dealing with a pension fund or a provident fund. So pension interest is the benefit that the member would have received had he resigned from his employment on the date of divorce. So, and is it to paraphrase? I'm paraphrasing here, but that's in a nutshell how pension interest is defined in terms of paragraph A of that definition in Section 1 of the Divorce Act. So this question that you ask is the reason why so many pension funds reject divorce orders that have wording that refers to something other than pension interest. So we often say A retirement fund can only pay pension interest, nothing else. Now, the unfortunate thing is that when the attorneys are sitting and they're drafting their papers, drafting the settlement agreement or drafting that draft order, you know, to one's mind, you think about pension interest as either, as you said, Albert, you know, a monetary portion within the fund where it is the capital, the contributions that were paid in by the member over time, plus interest, which is the growth earned in the market as the money is invested, right? To someone else, when they think of pension interest, they are thinking interest in the sense of entitlement. So this is pension interest because it's the non-member spouse's entitlement to the money because they were married in community of property. Now, if you present a divorce order that refers to provident fund interest, pension value, or things like that, or in some cases, we see divorce orders that refer to fund interest. So we say that is ambiguous for the fund. We cannot pay that because we don't know what you are asking us to pay. You are referring to fund interest. That sounds like you're referring to growth. That is the interest earned in the market as the money is invested. And in which case we cannot pay that. Because remember, as I said in the previous slide, when we're looking at the protection of fund benefits, that Section 37A is saying fund benefits are protected. They may not be reduced. They may not be attached. They may not be ceded or hypothecated. It even specifically says that they may not be subjected to attachment by order of court. However, as an exception to that rule, Section 37D1D Roman numeral 1 of the Pension Funds Act, so that's 37D1D1, that says if a retirement fund is presented with a court order that was issued in terms of Section 78A of the Divorce Act, then the retirement fund may reduce the member's benefit in order to satisfy the claim that is presented. So that's the divorce claim, right? You have an order granted under Section 78A of the Divorce Act. And when you go to Section 78A of the Divorce Act, you will see that it actually empowers or authorizes a court that's hearing a divorce matter to make an order that a portion of the member's pension interest be assigned or awarded to the other party, to the non-member spouse. So in Section 78A of the Divorce Act, there's specific reference to the word pension interest. And in the Divorce Act, they define this pension interest as the full amount that the member would have received had he resigned from his employment on the date of divorce. So now I have to go a little further and also explain that given that definition of pension interest, you will see that the requirements are that number one, the member must be in active service on the date of divorce. Because if the member has already resigned on the date of divorce, then we cannot say that here's a notional benefit that the member would have received had he resigned on this date. Excuse me, particularly because he's incapable of resigning on that date of divorce. So there's an SCA decision of 2011 in the matter of Eskom Pension and Provident Fund versus Krugel, where the Supreme Court of Appeal actually dealt with a matter like that, where the retirement fund still had the member's money. The member had not yet received payment of his fund benefit, but he had been out of service for many years by the time he got divorced. And the fund refused to pay that benefit. And the SCA agreed that on the interpretation of the definition of pension interest, it is a requirement that the member must be in service on the date of divorce. But that's specifically in relation to a pension or a provident fund. That doesn't apply to a retirement annuity fund or a preservation fund. I hope that answers your question, Albert.
Thank you.
Thank you. Just a reminder to everyone, please remember that, you know, at any point in time, you may stop me, just unmute yourself, state your name, and I'll let you have the floor. So moving on then, still on the clean break principle. So we've explained that we spoke about how prior to 13 September 2007, a non-member spouse would have to wait for a member's exit event before the non-member spouse could be paid his or her portion of that pension interest, and how it didn't make sense. So then the Pension Funds Act was amended to allow immediate access to this divorce benefit, and that's what we refer to when we speak about the clean break, right? You got divorced, it's all over now, the two parties go their separate ways. You don't have to, you know, keep contact with your ex-spouse to check if they're still working there, to check, you know, if they are thinking of resigning. You can just receive what is due to you and move on in your separate direction. Now I'm going to go into the provisions of the Divorce Act. So pension interest, as I mentioned just a few moments ago, is specifically defined in Section 1 of the Divorce Act. There are two paragraphs to that definition of pension interest. Paragraph A applies to a pension fund or a provident fund, and paragraph B applies to a retirement annuity fund. So Section 1, paragraph A of the definition of pension interest provides that in relation to a party to a divorce action who's a member of a pension fund, excluding a retirement annuity fund, means the benefits to which that party as such a member would have been entitled in terms of the rules of that fund if his membership of the fund would have been terminated on the date of divorce on account of his resignation from his office. So in short, pension interest is the benefit which the member would have received had he resigned on the date of divorce, right? Now, this link to, or this reference to resignation is a little problematic, because if practically what it means is that if someone understands how pension interest works, or if someone is going through divorce proceedings and they happen to have a chat with an attorney who understands how it works, it means that that member could easily, you know, I mean, especially with divorce proceedings where it's contested, the parties will exchange their pleadings and all of that. Pleadings will close, then you'll apply for a trial date. Now, knowing that there's a trial date allocated, the member who wants to deny their soon-to-be ex-spouse a portion of his or her pension interest can easily decide that, you know, I'm going to resign from my job. I'm going to resign just before that date of the hearing of the matter. And, you know, normally when people are going through divorce proceedings, they're not even living together anymore. So my spouse will not know that I've resigned. They're not going to see me sitting around at home. They'll just think that everything is okay. You know, we're on track. They're looking forward to the date of the hearing of the matter. Now, on the date of the hearing of the matter, the order will be granted, and the order will provide that whatever portion of the member's pension interest is awarded to the non-member spouse, and the non-member spouse will then submit a copy of that divorce order to the member's pension fund. Now, when they submit that to the fund, we say, we've looked at the order, it looks okay, wording looks all right, but there's just one issue, and the issue is that the member was not in active service on the date of divorce. So referring back again to the definition of pension interest, referring to the SCA decision in the case of ESCOM Pension and Provident Fund versus Krugel, we're going to say this order is not enforceable against the fund. We're sorry, but we cannot pay you a divorce claim. Yes, we still have his money. We haven't paid him as yet, but he resigned just before date of divorce. So in that case, it allows people the opportunity to cheat their ex-spouses out of that portion of their fund benefits. Now, in practice, for pension funds, what we find at times is that the attorney representing the non-member spouse will catch wind of the fact that the member has resigned, and the attorney will write to the fund and say, I've been made aware that this person has resigned, they're about to leave service. Please note that there are divorce proceedings underway. May we please have your undertaking that you will not pay the member, because we intend to claim 50% of his pension interest once we finalize the divorce matter. Now, what we do in practice is that we normally would write back to the attorney and say, we're sorry, we cannot accede to your request. So the reason is that, firstly, in terms of how a pension fund operates, a pension fund is much like a magistrate's court. We are a creature of our rules. So we cannot do anything outside of what our rules provide. So our rules provide that whenever there's an exit event, be it withdrawal due to resignation or dismissal or death or retrenchment, we will pay that benefit to the member. That is our promise to the member. We are contractually bound. We are also bound in terms of legislation, in terms of Section 13 of the Pension Funds Act, which makes the fund's rules binding on the fund and all parties who claim a benefit under those rules. So we have to pay the member. We cannot agree to withhold payment on the basis of a request from the attorney. Now, what some attorneys do in that instance is that they go and they apply for an interdict. They apply for a court order to stop the fund from paying the member his or her withdrawal benefit. Now, in a case like that, and because we are a pension fund, we're not a profit-making organization, we have to take care of the money that we have. It's the members' money. We don't like to engage in litigation. So when you serve us with a notice of application for that interdict, we will say we'll abide by the order. If you do have the order granted, we'll abide by it. We'll hold on to the member's money, right? Because it's an order of court, we will say to the member, sorry, we cannot pay you right now. We have to wait because here's a court order. We are interdicted. Now, at the end of the divorce proceedings, the attorney who interdicted the fund from paying the member his benefit will still submit that divorce order with a view to claim that portion for their client. Now, that takes us back again to the same position where we say we withheld payment because it was on the basis of an interdict. However, we cannot pay a claim for divorce benefits because there is no pension interest, because the member was not in active service on the date of divorce. So in a way that makes, interdicting the fund a bit of a futile exercise because you still cannot get that money directly from the fund. You may find other ways. Perhaps you can, put pressure on the member to agree to pay whatever is due to the non-member spouse as soon as he gets paid his his withdrawal benefit. But you cannot get that money directly from the fund. And there is something that it's a defect that cannot be cured. You cannot amend the court order in any way to get the money. I've seen people try to amend their court order to now provide that they want 50% of the members' withdrawal benefit. When they present that to us again, we say we cannot do that. And we refer back now to Section 37A of the Pension Funds Act, which says fund benefits are protected. You can't attach a member's benefit, not even by order of court. So it creates a problem. Now, in 2014, the legislature, having become aware of this issue, this technical issue, this small technical issue, which creates a problem for the non-member spouse, who, in many cases, for those who are married in community of property, the law is clear, the legal position is clear about that marital regime. If you're married in community of property, it's 50-50. You share the assets and the liabilities. And, Section 7.7 of the Divorce Act also specifically provides that if parties are married in community of property, then the member's pension interest is deemed to form part of the joint estate, right? So entitlement is not in question at all, especially for those who are married in community of property. But now there's this small technical, gap that's available. And some people do actually resign with the specific intention to ensure that their soon-to-be ex-spouse cannot access that portion of their pension interest. In fact, in some cases, those who have good relationships with their line managers, they resign just before the date of divorce, and immediately after date of divorce come back into service and continue. And the non-member spouse cannot get any portion of that pension interest because of that small little technical issue. So in 2014, the legislature, National Treasury, let me say, it decided that they should amend the Pension Funds Act in order to resolve this problem. So this is in 2014. It's after the decision of the SCA, which was in 2011, in that Eskom Pension and Provident Fund versus Kugel matter. And now they amend Section 37D of the Pension Funds Act, and they specifically include the words, the capital value of a retired member's benefit. They also include, so they include the capital value of a retired member's benefit, and they also include the deferred pensioners benefit. Apologies for that.
So if I may interrupt you.
Sure, please go for it.
It's Monia speaking. I would like to pose a question while we're discussing interdicting of pension funds. I would like to know about parties married in a community of property where you are aware of a pension fund held, but your client is not aware of the details of the pension fund. And when requesting such information from the employer, they are normally not willing to share it on the basis of private information and so on and so on. Do you have any suggestions on how to deal with obtaining the information so that we can make sure from the beginning that the fund or the interest is cited correctly and everything is done correctly in the summons? Thank you, sir.
All right, thank you for that, Monia. So in terms of access to information, I would say, as a start, if the only issue is you don't know the name of the pension fund, because it has to be named in the order, I would refer you to section 37D 4A Roman numeral 1 of the Pension Funds Act. So that's 37D 4A1. And it says that that pension interest must be deducted by the pension fund or pension funds named or identifiable from the decree. So, and that's the standard that we apply in the industry, that the fund must be named, or it must at least be identifiable. Now, in cases where the attorney does not know the name of the fund, you can refer to the name of the employer which participates in the fund. At times, employers have a number of retirement funds that they participate in. So, for example, in the chemical industry sector, there's about 4 retirement funds which the employer could be participating in. Some participate in all 4 at the same time. So if you ensure that you put in the name of the employer, you put in the member's ID number or member number, if you have that, that will allow the retirement fund to now look into its records and see if they have the member. I'm going to make an example and say, let's say the person works for Coca-Cola. You don't know if he's a member of the Coca-Cola fund that is administered by NBC Fund Administrators, or if he's a member of the Coca-Cola fund administered by Liberty, or the fund administered by Old Mutual. So you would say that the plaintiff is entitled to 50% of the defendant's pension interest held in the retirement fund where he's a member by virtue of his employment with Coca-Cola Pty Ltd under member number 1234 with ID number XXX, right? So that helps to make it generic enough to be received by all of the 4 retirement funds, and that they must go into their records and check if they have that member's benefit or not. But that's, the bare minimum. In terms of access to information, and I understand that at times for you as an attorney, you need more than just the name of the retirement fund. You need to understand, is there a benefit? Perhaps you may be even wanting to know how much is available, in that member's record. So in that case, what you need to do is to submit a PIA application. So if you know, the name of the employer, you can ask them, who's the fund administrator. If they give you that information, then you submit a PIA application with the administrator. Normally, retirement funds and fund administrators are not resistant to give that information if there is a basis. So if it's backed by a PIA request, by PIA, I mean the Promotion of Access to Information Act, then the fund or the administrator will provide that information on the basis that the person requesting the information, which is the non-member spouse, is entitled to it because they need it to assert their rights. So there's a legal right, there's an entitlement. That is why the non-member spouse needs that information. If the employer does not give you that information, then you submit a PIA application to the employer to give you that information. So, I don't know if you have followed some of the cases that are out there on PIA, but you see that people are often amenable to giving information because it's a PIA request, because if they don't give you that information, then you can take that matter to the High Court and get an order to compel them. So it's even in the current climate where we have the Protection of Personal Information Act, it is linked to PAYA, and you can get that information in that way. I hope that helps, Monya.
Andrew, sorry, it's Rhonda speaking. If I could just also say something in terms of a pay request, maybe the companies somehow or the other delay the information. And what we particularly find we deal a lot with is actually the subpoena of information, which is dealt with on a more urgent basis to provide the information available.
Yeah, Rhonda. That also sounds like a good idea. What I've seen, my observation in practice is that subpoenas are normally used in the maintenance matters. It's not often that we get a subpoena in relation to a divorce matter. I'm not exactly sure why it is that way. I suspect it may be a little difficult to enforce the subpoena in divorce matters in the event that there's no cooperation on the part of the party that holds the information. But I mean, I totally agree. If you can subpoena the information, then that also is something that should be helpful. Okay.
Thank you very much. That helped me a lot.
Thank you, Monya, and thank you, Rhonda, for assisting. See, this is why it helps when we put our heads together and interact together to find these workable solutions. Because our experience is also different, right? Now, I'm going to move on to, my apologies. I need to complete the point first. So we were talking about the definition of pension interest, and I was talking about how National Treasury then amended Section 37D with effect from 28 February 2014. So what they did was to introduce two new categories to Section 37D1D1 of the Pension Funds Act, and that is deferred pensioners and pensioners who have retired but still have a capital value within the fund. So just so that we are all on the same page, when we speak of deferred pensioners, we speak about people who are not retired, right? Even though I know it's a little misleading because it refers to pensioners, but a deferred pensioner is not someone who's retired. So some fund rules, not all pension funds, but some pension and provident funds allow for a member who was contributing to the fund, who has his employment terminated, but before normal retirement age. So while you're still young, while you are still of an age where you can continue working, you haven't gotten to retirement ages yet. If your employment is terminated for whatever reason, be it resignation or dismissal, you may be allowed to choose to leave your money in the fund. So what would normally happen in those scenarios is that the fund rules provide that if you defer your benefit, you become a deferred pensioner. You may not access your benefit at any point in time, but you must wait up until you get to normal retirement age, at which point you will then receive a retirement benefit from the fund. So retirement funds like that are normally defined benefit funds. They add a sweetener to make it attractive for the member to want to leave his money in the fund. So if you leave your money in the fund and you become a deferred pensioner, your benefit is going to increase nicely over time, And they use that to make it attractive to people to say, you know, you may have 100,000 today, but if you leave your money with us and you get to normal retirement age, in 20 years time, your 100,000 will be R1 million. I'm just making an example. So those people become deferred pensioners. And in that Eskom Pension and Provident Fund versus Krugell case, that's exactly what had happened, that the member was working for Eskom and his employment was terminated at some point, and much later on, he got divorced. And in the divorce order, between himself and his ex-spouse, they attempted to now share this pension interest that's sitting within the Eskom Pension and Provident Fund. But the fund said, no, there's no pension interest. On the interpretation of pension interest, there is no pension interest here. And that's when, you know, the dispute then ensued. The parties went to the pension fund's adjudicator. The adjudicator issued a ruling which was in their favor. The fund was still not convinced that that's how it should be interpreted, and the fund took the matter on appeal to the High Court. The High Court also agreed with the adjudicator's ruling, thereby ruling in favor of the divorced parties. And the fund was still not convinced, and that's how the matter ended up at the Supreme Court of Appeal. So some 3 years later, following that Krugell decision, Section 37D1D is amended to specifically include reference to deferred pensioners. They also amend that section to include reference to a retired member, a pensioner who has a capital value within the fund, right? Now that section reads as follows. I'm just going to read that out to you quickly. It says that a registered fund may deduct from a member's or deferred pensioner's benefit, member's interest or minimum individual reserve, or the capital value of a pensioner's pension after retirement, as the case may be, any amount assigned from such benefit or individual reserve to a non-member spouse in terms of a decree granted under Section 78A of the Divorce Act. I'll stop there. So the intention was good. It's a good intention. It makes sense. But there was a problem with that amendment. Now, the problem is that in trying to make it possible for a retirement fund to pay a divorce claim in relation to a deferred pensioner or a retired member who's a pensioner, right? We are still going back to referring to Section 78A of the Divorce Act. Now, Section 78A of the Divorce Act refers to pension interest. So 78A provides that notwithstanding the provisions of any law or the rules of any pension fund, the court granting a decree of divorce in respect of a member of such a fund may make an order that any part of the pension interest of that member, which by virtue of subsection 7 is due or assigned to the other party to the divorce action concerned, shall be paid by that fund to the other party when any pension benefits accrue in respect of that member. Now, in referring to pension interest, we still need to go back to the definition that talks to the benefit that the member would have received had he resigned on the date of divorce. Now, it now brings us to a point where we say, for a deferred pensioner, understanding that he is someone who used to work for the employer, left the employer's service, and then decided to leave his money in the fund. Is he capable of resigning on the date of divorce? The answer is no. He cannot resign because he's not employed by that participating employer within the fund. In relation to a retired member who is now a pensioner and receiving a pension from the fund, even though he has a capital in the fund, there's a value which we could say this sits in your pot as a member, right? There's a capital value. But are you capable of resigning? Once again, the answer is no, because you retired, you are no longer in active employment. Now, for that reason, it makes that amendment completely futile. It cannot be given effect, it cannot be implemented because there's reference to pension interest. So, excuse me, following that amendment in 2014, the pension funds industry engaged National Treasury and representatives from SARS and the Financial Sector Conduct Authority on this issue, and made them aware that, you know, there was that oversight, and now we can't give effect to this. You know, the regulators made the industry aware that, you know, they've asked the Department of Justice to consider amending the Divorce Act, because the Divorce Act sits within, it's within the custody of the Department of Justice. It's not within National Treasury and Department of Finance and them. But we still have not seen any amendment to either Section 78A of the Divorce Act or to the definition of pension interest in the Divorce Act. So we still sit with a problem where we can only pay a divorce claim if the member was in active service on the date of divorce. And that is by virtue of the definition of pension interest in Section 1 of the Divorce Act. Do you have any question or comment before we move on to the next slide?
Yes, I do, Mr. Motivi. This is Masika.
Okay.
Can you hear me?
Yes, I can hear you, Masika. Please go for it.
Yes, I was saying that I think there has to be an amendment in respect of the matter that the pension member will be intentionally resigning from his employment, and therefore the amendment should go to the effect that a pension fund should check first before the employer should check first if the pension member does not have any proceedings against him or her, so that they make a provision for this person who's claiming or who has to benefit from the pension interest. They should check first whether the person is not having any divorce proceedings, and whether the person at the time of resigning is capable of resigning or retirement. And even so, those things need to be included in there, because the movement made by the pension member, the pension fund member, is intentional in that they don't want to have the pension interest claimed from their pension benefits. Thank you.
Thank you, Masika. Yeah, I think that could be a little problematic. It may be problematic because now, you know, we would be going into a place where we are tampering with people's liberties, right? You know, a person should be free to resign from employment if they don't want to continue working there. You know, I mean, what would you do in that case if the member says, yes, I acknowledge that I have divorce proceedings underway. I acknowledge that my soon-to-be ex-spouse wants 50% of my pension interest, but I've decided that I don't want to work here anymore. I'm resigning. So I don't think that any court would grant you an order for specific performance, you know, to compel that member to stay in employment. It makes it difficult, and now you're also including the employer and possibly the fund in you know, the personal matters between the divorcing parties. I think what could really help in a really practical way is that we must relook this definition of pension interest. I think if pension interest was, I think if it was defined as any amount that the fund holds at the time of receiving the claim, then that would make things completely different. I mean, there'd still be members who try to resign and claim their money quickly before they can, have that divorce order granted. But it would be a little different. The picture would be different because currently it means a person can just resign and not even claim that money, not even touch that money. It's still with the fund, but their non-member spouse can't claim it. And that is really sad. I don't think, that's really what the legislature intended when they were drafting that definition of pension interest. Another thing is to say that, normally from our point of view as retirement funds and fund administrators, when we deal with cases like that where we have to reject that divorce order, we normally say to the attorneys that, your client can still have recourse against the member directly. So you have a settlement agreement, that's a contract, right? It has been made an order of court. So you have two things. You have a contract that's binding, you have a court order. That can be enforced directly against the member himself. It doesn't mean that if you can't get the money from the fund, that you're completely at a loss and that, you must walk away with nothing. You can still, if the member has something that you can look to attach in order to get the same value that you would have received from the fund. So that's something that, the attorneys can consider. But, for most South Africans, that money that's sitting in the pension fund is really the biggest asset that the member actually has. You may find that there's no property, movable or immovable that can be attached. So it makes it difficult for the non-member spouse to get something out of the member in a case like that.
Mr. Matibi?
Yes. Sorry, who's speaking?
It's Diane Smart. I just want to know, are you aware of any efforts or any kind of movement in the Department of Justice to amend the definition of pension interest at this stage, or is it just something that's sitting on the back burner?
Well, to be honest with you, Diane, I'm not aware of any movement in that regard. No, not at all. Yeah, and I mean we're all at the mercy of this definition. As we've seen with the efforts that were done some 8 years ago, even if we amend the Pension Funds Act in however way we want, we are still going to revert to that definition of pension interest. So yeah, that's really sad. And yeah, I'm not aware of any movement. I mean, there are a number of groups. We have a lobbying group for the pension funds industry. It's called the IRFA. That's the Institute for Retirement Funds Africa. And they interact with SARS, they interact with the FSCA and National Treasury on a quarterly basis. But it seems that the problem is that within government you have a problem where the left hand is not really talking to the right hand. I mean, as I said, it's been years since the FSCA and them said that they've requested this amendment. They've submitted the request to the Department of Justice, but we still don't have any movement on that.
Oh, that's a pity. Thanks for your reply.
Thank you.
Jackie here, Mr. Motibe.
Hi, Jackie.
Hi. So I'm actually an administrator for a pension fund. So this is very interesting for me. And just from my point of view, going back to the members trying to access their monies, we've actually put in place measures with our administrators, because the funds can now be taken to task if members resign, just to be employed again. So they're trying to access their monies, in any way that they can. So we get advised if, say, a member resigns and then within 6 months is employed again. And just on that, a few years ago, we saw a trend where members were trying to get their hands on their money. They were even going as far as getting divorced so that their spouse could access a portion of their benefit, but then they remained staying together after the divorce.
Yeah.
Yeah.
Thanks for bringing that up, Jackie.
Okay.
And that's valid. That happens. We see that in practice. I'll start with the last comment. People who get divorced just to access some money for financial relief. We've seen that over the years, where you find that if you look at a member's record, you find that he has 3 divorces over a space of 8 to 10 years. And in those 3 divorces, each time he's getting divorced with the same person or from the same person. So they divorce, they have a settlement agreement. They agree that the non-member spouse must be paid 100% of the pension interest. Something I'd like to highlight to the team, that it's possible. So there's nothing in law that regulates what's this portion that may be paid to the non-member spouse. So normally, with people who are married in community of property, because it's a 50-50 split, you find that it's 50% that is awarded to the non-member spouse, but there's nothing in law that says, it has to be 50%. So it's anything that is determined by the court. So if there's a settlement agreement between the parties and the court makes that settlement agreement an order of court, the parties have it fully within their control, anything between 0.1 and 100% of the pension interest. So we've seen those where there's a claim for 100% of the pension interest, and then a few years later, because we don't follow, as the pension fund or as the administrator, we don't follow what's happening in the member's personal life, right? We won't ask you to tell us if you marry again. All we have is your record. We maintain the record, we receive the contributions, we maintain all of that, the investments and all of those good things. And at some point we receive a divorce order. If it's enforceable, everything is compliant with the requirements, we pay the divorce claim. Then we continue once again with maintaining your record, and after some time, we receive another divorce order. So again, there's nothing in law that says that the fund is to look at the trend or analyze the trend, and also that the fund may be empowered to say no. There's nothing that allows that. So legally, whenever we receive that court order, that divorce claim, if it's enforceable, if it's fully compliant, we have to pay. So that has happened. It's something that is not abnormal in our industry. And to the first point that you touched on, Jackie, about trying to prevent people from exiting just to access a withdrawal benefit. So it's a hot topic right now. I think most of the people on the call would be aware that so from mid-December last year, National Treasury proposed what they call a 2-pot retirement system, because there's been calls from government, from labor, civil society, to say that a lot of people are struggling. They're in a desperate financial situation, and what's the use of having a lot of money saved up in a retirement fund when you need some relief now and you can't access that money. You know, we've seen the stories about people losing their houses, people losing their cars, people's children being kicked out of school due to non-payment of the fees. So what's the point if you have millions saved up for a day which may not even come? You know, you could die before you get to normal retirement age. So with all of those things in mind, you know, I think it was the Democratic Alliance in 2020. They made a proposal to Parliament to say, you know, since the COVID-19 pandemic, we should amend Section 19 of the Pension Funds Act, which talks about getting a loan from the retirement fund. So the Democratic Alliance was saying, let's lift some of those restrictions to allow people some access to their money. And then National Treasury then in mid-December last year issued the first proposal on a two-pot system, saying, you know what, actually going forward, we think that we want to change the retirement fund system to allow people some access to their money during the course of their employment, during the course of their membership of the fund, at certain intervals which we can regulate by law. So the second bit of you know, National Treasury's proposal on the two-pot system came out about 2 or 3 months ago, where, you know, they said, actually, you know, they want to take a different approach. They want to create 3 pots within the fund, where the first pot must hold all the money that has been paid up to date of implementation. The second pot will hold 1/3 of contributions that get paid into the fund going forward, and the third pot will hold the 2/3 portion. And for the members, at every annual interval, you can access the money that's sitting from the 1/3 contributions, subject to a minimum of 2,000 Rand. So there's still work being done around that. You know, for the defined benefit funds, a lot of work needs to be done so that we can understand how this 2 or 3 pot system is going to apply to those types of retirement funds. But we have also had rules for, I know with retirement funds such as the Gauteng Building Industry Pension Fund, for many years they've had a rule that says if a member is exiting employment, they will wait for at least 6 months before they pay that member a benefit. And how they justified that withholding for about 6 months post-exit was to say that their industry is small. And quite often you find that a member leaves employer A and goes to employer B, but both employers are participating within the same fund. So it's also messing up their administration system, because, you know, while I'm trying to exit this member on this record, I'm also receiving a new contribution for the same member. And, you know, that messes things up. When I'm applying to SARS for a tax directive, you know, it's weird that I'm trying to pay a member a benefit, yet I still have contributions that I'm receiving from him. So they justified it in that way. But it would, I think, again, my view is that it would be difficult to stop people from resigning, because now that goes towards, you know, personal liberties. That really would be something that I think, yeah, would not pass the constitutional muster. I think it would really be a difficult one. All right. Thank you, Jackie. I'm going to move on then to the next slide. So most of what you see on this slide, I've already touched on. And that's the nice thing about having a conversation, making it interactive. We get to touch on things, and we we paint a picture and we complete the puzzle properly. So now looking at the Pension Funds Act, the provisions of the Pension Funds Act, I started off by talking about how fund benefits are protected in terms of Section 37A1, and the exception to that protection is where the provisions of the Pension Funds Act or the Income Tax Act or the Maintenance Act allow for that reduction, transfer, or attachment of a fund benefit, right? So there is this saying that is quite popular. People say that the two things that are definite in life are death and taxes, right? So tax, of course, you know, the payment of a fund benefit is subject to tax. So the Income Tax Act will certainly be an exception to that protection of fund benefits. So whenever a retirement fund is paying a benefit to a member, in terms of the Income Tax Act, the fund is deemed to be an employer, and the fund is obliged to deduct and withhold the tax that's applicable to that benefit. The Maintenance Act also comes in as an exception, where you find that the member owes maintenance and there's a maintenance order. And, you know, in terms of Section 16 of the Maintenance Act, the monthly pension that is payable to a retired member can be attached for purposes of maintenance. And also in terms of Section 30 of the Maintenance Act, there is the section that talks about attachment of a debt. The fund benefit of a member can also be attached as a lump sum if there's arrears maintenance that is to be paid. So the provisions that allow this exception within the Pension Funds Act, as I mentioned before, you know, that's Section 37D1D1. And I've read out the provision to you. With my own emphasis, I've underlined the important parts that a registered fund may deduct from a member's minimum individual reserve, any amount assigned from such individual reserve to a non-member spouse in terms of a decree granted under Section 78A. So that's also how the section used to read before that amendment in 2014. In 2014, they added reference to deferred pensioners' benefit and reference to the capital value of a pensioner's pension after retirement. And they also added reference to an order made by a court in respect of the division of assets of a marriage under Islamic law pursuant to its dissolution. So even for marriages which were entered into and dissolved in terms of Islamic law, there is still a problem for those marriages in our industry. Because I think, you know, we'll all agree that our Constitution affords all people, you know, the right to equality, the right to freedom of religion, you know, the right to not be discriminated against on the basis of your religion or your belief, amongst other things, right? So what you find is that at times people who are, I guess, Islamic, you know, people who are of the Islamic faith, let me put it that way, get married in terms of their belief system, and then they also get divorced in terms of their belief system, right? So if you're married in terms of Islamic law, you wouldn't, you know, get a decree of divorce as someone who was married in terms of civil law. So the problem now becomes that if those parties were divorced in terms of Islamic law, or the tenets of a religion. Let me not limit this to the Islamic faith. If you are married and divorced in terms of the tenets of a religion, then if you agree to share the pension interest that you have upon divorce, it becomes problematic because, number one, you do not have a divorce order. You don't have a divorce order contemplated under Section 78A of the Divorce Act, right? Now, in some of those cases, the parties go and apply for, so they apply to court to have a settlement agreement that they entered made an order of court. Now, within that settlement agreement, they put in wording that refers to Section 78A. Then the parties present that settlement agreement, which has been made an order of court, to the fund for payment of pension interest. Now, the difficulty for the fund is that when paying this claim for divorce benefits, we pay on the basis that Section 37D1D allows us to do that. But that section refers to an order granted under Section 78A of the Divorce Act. Now, we don't have an order granted under Section 78A of the Divorce Act, even though the settlement agreement refers to Section 78A, but we know that it was not granted in terms of that section because it was not, the court order that is being presented is not an order that was made by a court that was considering the divorce matter between the parties. Now, another thing that is problematic is that, again, we're paying pension interest. And pension interest is defined as the benefit that the member would have received had he resigned on the date of divorce, right? Now, how do we determine the date of divorce? Because that's actually our calculation date. On that divorce date or date of divorce, that is where we say we look at the member's value, what's in the member's pot of savings as at this particular date. Now, in the case of people who got divorced in terms of the tenets of a religion, that is difficult because they divorced on one date and then they applied to court to have their settlement agreement made an order of court on another date. And so there are a number of dates. There's the date of actual divorce, date of application, that date that the settlement agreement was made an order of court. You have the date that the settlement agreement was signed. There isn't that specific date to use and say, this is the date of divorce as contemplated in Section 78A of the Divorce Act. So that becomes problematic for retirement funds. Again, another issue that needs to be attended to, that needs to be fixed, that falls, within the power and authority of the Department of Justice and Constitutional Development. So I'm going to move on now to so this is just in relation to what we just spoke about. Just a quick question to consider, and that is in respect of which categories of members can a claim for divorce benefits be paid? Can it be paid for active or in-service members? Can it be paid for a deferred pensioner? Can it be paid for a retired member who's a pensioner? Can it be paid for paid-up members? And what about members with unclaimed benefits? So to answer these questions, one needs to just simply refer back to the general principle. The general principle is that if there is pension interest, we can pay. If there isn't pension interest, then we cannot pay. So when you look at the first bullet point, active or in-service members, there's definitely pension interest because he's in service. We can say this is the benefit he could have received had he resigned on the date of divorce, right? With deferred pensioners, if he became a deferred pensioner and only divorced after, then there is no pension interest because he's incapable of having resigned on the date of divorce. The same applies to retired members, paid up members, and members with unclaimed benefits. It's all about figuring out whether the member was in active service on the date that the divorce order was granted. And in respect of which types of marriages can a claim for divorce benefits be paid? Civil marriages, yes, we can pay because we can have an order, a divorce order in terms of Section 78A of the Divorce Act. For customary marriages, remember that they are regulated by the Recognition of Customary Marriages Act, and they are dissolved by an order of court. So you can have a divorce order in terms of Section 78A of the Divorce Act. So we can pay in respect of that marriage. For marriages in terms of Islamic law or a marriage in terms of a religion, any belief system, or a partnership, with or without a cohabitation and separation agreement, we cannot pay because for the last three bullet points, those three categories of marriages, you cannot have a divorce order in terms of Section 78A of the Divorce Act. So moving on then to the 5 requirements for an enforceable divorce order. So the requirements are that the fund must be named, or it must at least be identifiable. So
I'm sorry, it's what I.
Oh, my apologies, I didn't get your name. Can you hear me?
I can, yes.
Oh, I'm sorry, I didn't get your name.
Mareike.
Oh, Mareike. Please go for it.
Thank you. I just want to ask a question regarding the civil unions and partnership. Remember that the Civil Unions Act makes provision for parties to decide whether they want to be considered married or partners in a civil union. Is there a distinction when that application is made between the two? So in other words, my question is, if under the Civil Union Act, I elected to be married as opposed to just be a partner in a civil union, how is that affected by the concept of partnership in your final bullet point?
Okay. So my understanding is that for those civil union partners or parties, is that if they are to be considered married, that means that in the event that their union is to be dissolved, then they need to get a divorce order, right? Yes. So in that case, it means that you must have a divorce decree to which Section 78A of the Divorce Act would apply.
Okay, so in other words, that means that the final bullet point, life partnership, does not apply to partnerships in terms of the Civil Union Act. So that's perfectly clear to me now. Thank you.
Yeah. So it's a matter of are you capable of dissolving the union through, or let me rephrase. Is the union is this marriage or union or relationship capable of being dissolved by a divorce order?
Yes.
If it is, then then we need an order in terms of Section 78A of the Divorce Act. If it's not capable of, if it's impossible to get a divorce decree in terms of Section 78A of the Divorce Act, then we cannot pay this claim for pension interest.
Thank you very much. That's perfectly clear. Just something else. Albert Marie has another question in the comments box. Maybe Albert just wants to ask that question as well after me. But thank you very much. You've answered it perfectly. Thank you.
Thank you. Albert, the floor is yours. Do you want to come in?
Thank you. It's once again the question about the definition of pension interest. So if we look at section 37D1D, small Roman 1, there's reference to benefit, and then in the second instance, members' interest, and then in the third instance, minimum individual reserve, and then in the fourth instance, capital value. For that context, are they then all synonyms? Benefit, interest, reserve, capital value, all of those.
Yeah. So in a technical way, they are not the same thing, but looking at it simplistically, it's the same thing. So benefit, for example, is specifically defined in Section 1 of the Pension Funds Act as a benefit due to a member in terms of the rules. So meaning that there's been a trigger event, an exit event has taken place. So now a benefit is accrued to the member, you are entitled to payment of a benefit, right? Interest refers to your section within the fund, the pot that holds your money, right?
Okay.
And there is, so the only difference between benefit and interest is that interest and minimum individual reserve are what you have while you are still active as a member, while you are still paying money in, contributing and saving towards your retirement. But once an exit event takes place, then that money changes from being interest or minimum individual reserve, and it becomes a benefit, you see. So what they were trying to do with that is exactly the same as what I was explaining, to say that they were trying to make this a catch-all. They were trying to make it possible for a pension fund to pay a benefit irrespective of what we hold for the member, irrespective of the type of marriage that the member was involved in, irrespective of the category of member that the member is, whether you are active, you are about to leave, but we have your money still, or you are deferred pensioner, or you are retired and we're paying you a pension. So that's what they were trying to achieve with that amendment in 2014. But as I said, it could not work because we're still held hostage by that definition of pension interest in the Divorce Act.
Thank you.
Mr. Matibi, Diane Smart again. Just a thought on this issue. Given that the problem seems to be the mention of the words pension interest, and Section 7.8, could it not be resolved by changing the wording just to say in terms of a divorce order, without necessarily kind of referring to those particular sections or definitions? Anyway, it's just a thought, because that's potentially an amendment that could be affected in the Pensions Fund Act without amending the Divorce Act.
Yeah, that actually sounds like a good suggestion, Diane. I've never thought about it that way, but that sounds like a really good suggestion, to say that let's move away from this Section 7.8A and its reference to pension interest, right? Let's just refer to divorce order. And in that case, yeah, it has to be just a divorce order that should suffice because it's an order for the dissolution of a marriage. And I'll tell you, you know, in terms of, if you look at the practice in terms of maintenance orders, it's different and not as complex because they don't have this reference to pension interest. So with a maintenance order, section 37D1D, Roman numeral 1, so that's D1D, Roman numeral 1A. That refers to maintenance. So that says that a registered fund may deduct from a member's or deferred pensioner's benefit, member's interest or minimum individual reserve, or the capital value of a pensioner's pension after retirement, any amount payable in terms of a maintenance order as defined in Section 1 of the Maintenance Act. So when you go to the Maintenance Act and you look at what is a maintenance order as defined, it simply provides that a maintenance order is any order issued or made by a court in terms of which a party is required to pay maintenance for another party. And that is quite simple. So we don't have to crack our heads thinking about, you know, if I receive an order from the High Court, is it a maintenance order? Or must it only be an order that comes from a special court that is a maintenance court? You see, because in divorce proceedings, you can include provisions that deal with maintenance, right? And you may be having a divorce order issued by the High Court, but for as long as that order also includes some provision about the payment of maintenance between the parties, that qualifies that order also as a maintenance order. So for maintenance, we pay these claims even if the member has exited. In some cases, people who really don't want to pay maintenance, you know, what normally happens is that the first order granted by the maintenance court would be an order granted perhaps under Section 17 of the Maintenance Act, where the member has consented to the order being made, or they had a maintenance inquiry and the court actually granted an order that you know, that person must pay maintenance. Now that's normally the first order, and if that person defaults and doesn't pay maintenance, then the person entitled to maintenance would go and enforce the order. So the maintenance investigator would look at, are there any assets to attach? Perhaps there aren't any assets, so they don't issue a writ, but then they issue an emoluments attachment order, right? I think that's in terms of Section 26 of the Maintenance Act. I could be wrong. So what happens is that then the money is deducted directly by garnishee order from that person's employer. So from his salary or earnings, that's where they deduct the maintenance money. In some cases, those people then actually resign from employment, and then the maintenance officer would make another application to court to say that, you know, we believe that this person is has resigned because they want to avoid paying maintenance, but we've been made aware that they are a member of a pension fund. So they then interdict the fund from paying the member until such time that that application for an order under Section 30 can be granted. So when we receive those interdicts, again, we abide by the interdict. We don't want to get involved in the personal affairs of the member. Also, we don't want to incur all these litigation expenses. So we abide by the order. We hold on to the member's money. He's resigned, but we're holding on to the money on the strength of an interdict. By the time they conclude those maintenance proceedings and get an order under Section 30 of the Maintenance Act, they present that to us and we make a deduction and we pay whatever that is due in terms of that order. So it's less complicated. It's really easy, it's straightforward. There aren't all these issues about is there pension interest? Was he employed on the date that the order was granted? What type of marital system was he married in terms of, do we have an order under Section 78A? So I think, Diane, yeah, I completely agree with you. That could be something that helps to cure this position that we find ourselves in.
Thank you for your response.
So moving on then to the types of the requirements for an enforceable divorce order. I think I should just mention first that when we refer to an order being enforceable against the fund, we're not saying that the divorce order is not a valid divorce decree. All we're saying is that for the fund, as a party that is expected to perform a specific act, we do not believe that legally we are obliged to do so. So it doesn't mean that the fund is trying to pronounce on the validity of a divorce order. It just means we're saying we've looked at it and we don't believe that legally we're obliged to do anything. So if you, as the attorney who was involved in the divorce, feel unhappy, dissatisfied about that, then you can consider your options. You can lodge a complaint with the Office of the Pension Funds Adjudicator against that retirement fund, or you can consider other options such as contempt proceedings against the fund, or trying to get an order to compel the fund to pay. But it's important that I make it clear that when we say that an order is not enforceable, it's not that we're saying it's invalid. We're just saying that we cannot perform whatever act that you expect of us. So the requirements for an enforceable divorce order are firstly that, and this is not in any particular order, but the first requirement is that the fund must be named, or it must at least be identifiable. Now, this requirement stems from legislation and common law. So if you look at Section 37D4A Roman numeral 1 of the Pension Funds Act, so D4A1 says that that pension interest that needs to be paid to the non-member spouse must be deducted by the pension fund or pension funds named in or identifiable from the decree. So that's legislation, but also common law. We all know that you need to name, you need to identify a party if they are to be compelled or required or directed to perform any act in terms of a court order. If you live in a standalone house and you receive a court order, if you're served by the sheriff with a court order, you were never served with any papers before, you were never cited as a party to any proceedings, but you are served with an order that says, the tree that you have in the front of your house must be cut down. It's an order for specific performance. You must cut down your tree. Would you cut down the tree if you are not named as the person directed to do that? I would say no. I wouldn't cut down my tree. I would only abide by that order if I was served before and if I was named or identified in my apologies. Is that a question? I think I heard something.
Umthengi nomthengisi qha.
I think someone's mic is not muted.
Siphilile nathi tata kuhla khona. Umthengi okanye umthengisi. Okay, umthengisi yena. Umthengisi then umthengi. Sobona ke mthengi. Ndizawufunda apha kule ndawo jikela so.
Tim, can you please assist? I'm not sure whose mic is not muted.
Excuse me, Masoka.
Masoka, could you please mute yourself, please?
Sorry.
You're interrupting us, please.
Thank you, Masoka. So that's the basis for that first requirement. The fund must be named or it must be identifiable. The second requirement is that the portion awarded to the non-member spouse must be stipulated, or it must at least be determinable. So once again, you want us to pay pension interest, you need to tell us how much. Remember that I mentioned that the pension interest that is payable by a retirement fund to a non-member spouse is not regulated anywhere in law. So, it doesn't have to be 50% all the time. I've seen in some cases that the parties, want to set off certain things in terms of their patrimonial benefits. Then, perhaps the one party will instead or in lieu of the house being sold and the proceeds being divided equally, then the one party will agree to give more than 50% of their pension interest, and it is to cover those costs or that portion of the other party's share in the immovable property. Excuse me. The third requirement is that the fund must have been, my apologies. The third requirement is that the member must have been in service on the date of divorce. We've exhausted this matter. It's because of the definition of pension interest in relation to a pension or a provident fund. Now, I must also add that the requirement doesn't apply for a member of a retirement annuity fund. This is because with a retirement annuity fund, you don't become a member by virtue of your employment. So they were designed for people who are self-employed. So if a member has a retirement annuity fund policy, and they get divorced, then the non-member spouse can receive a portion of the pension interest irrespective of whether the member is employed or not. As long as there's money in that retirement annuity fund, as long as there's a policy with some monetary value and the member has not retired, then that can be paid to the non-member spouse. The order must refer to the portion awarded to the non-member spouse as pension interest. Once again, we see some divorce orders that say 50% of the plaintiff's fund value or 50% of the plaintiff's provident fund interest, just because, the member is a member of a provident fund. Please remember that pension interest is pension interest across all funds, irrespective of the type of fund. It's always pension interest. So even if it's a provident fund or a retirement annuity fund or a preservation fund, what the member has in the is always pension interest, because that is something that is specifically defined in Section 1 of the Divorce Act. And finally, the member must be, my apologies, the fund must be ordered to pay that pension interest. So your order must name or identify the fund. The portion awarded to the non-member spouse must be set out in clear terms. It must be stipulated or determinable. There mustn't be any ambiguities there. The member must be in service on the date of divorce if it's a pension or provident fund. The divorce order must refer to the portion awarded to the non-member spouse as pension interest. And finally, the fund must be ordered to make that payment. So the wording used should not be capable of being interpreted to mean that the member will pay that himself. So it must be clear that the fund that is identifiable is ordered to make that payment. Do we have any question or comment before I go into the frequently asked questions? All right, I'll go now into the frequently asked questions. So these are just frequently asked questions, and I think it helps to go through them and also discuss the answers to the frequently asked questions. So the first one is, can the fund give effect to an order that requires the interest at a rate of, let's say, at mora rate, right? Calculated from date of divorce to date of payment, should be paid to the non-member spouse in addition to the 50% of the pension interest awarded to him or her. Now, this is what we do see at times, that there's a divorce order and say it talks about 50% of the member's pension interest is awarded to the non-member spouse. However, then it goes on to say that the non-member spouse shall be entitled to interest at mora rate from date of divorce to date of payment. Now, we cannot do that. A pension fund cannot pay interest or growth over and above the pension interest to the non-member spouse. And the reason for that is that it's specifically set out in the Pension Funds Act in section 37D4C. It specifically says that a non-member spouse is not a member or beneficiary in relation to the pension fund and is entitled to the accrual of fund return from date of the deduction contemplated in paragraph A2 until payment or transfer thereof, but not to any other interest or growth. So the accrual of fund return that is referred to in section 37D 4C2 is that interest that should actually be seen as late payment interest that I referred to earlier when I said that, section 37D sets out timelines to say a fund has 45 days to consider if the divorce order is binding against it. Then the fund must allow the non-member spouse to make a decision on how that divorce claim should be paid, and the non-member spouse would have 120 days. Thereafter, the fund would have a period of 60 days to pay that benefit in terms of the election made by the non-member spouse. So in the event that there's a delay in paying that claim by the fund, if the fund takes longer than 60 days, only at that point would the non-member spouse become entitled to some interest or growth. But that's something that you don't need to deal with in your divorce order, because it would apply by operation of law, because section 37D already sets out all of that. So it's my opinion that it's best that in drafting that settlement agreement or the draft order, you do not try and deal with that particular issue. The next question is, when must the fund pay the non-member spouse his or her claim if the divorce order is enforceable? I've already touched on that. The fund has 60 days in terms of Section 37C. My apologies, in terms of Section 37D of the Pension Funds Act. If a divorce order is unenforceable against the fund due to the wording, will the fund accept an addendum to the settlement agreement or a written consent by the member to pay? So we normally advise retirement funds not to do that, not to accept an addendum or a written consent or an affidavit by a member. And that is because legally the fund would be paying that divorce claim on the strength of Section 37D1D read with Section 78A of the Divorce Act. So if you don't have an enforceable divorce order, the only reason that would allow the fund to go against Section 37A, which is the protection of fund benefits, would be if you receive an enforceable order. So the parties would have to go and amend the divorce order, and only then should the fund pay that claim. But outside of that, there shouldn't be any addendum, simply entered between the parties, not made an order of court that is acceptable for the fund to pay the claim. The next question is, can the portion awarded to the non-member spouse be paid into his or her attorney's trust account? We receive this quite often in practice from attorneys. And the simple response to that is no, we cannot pay that to the attorney's trust account. So I understand that at times there is an arrangement made between the attorney and his or her client that I'll do the work for you. At completion of the matter, you are going to receive a benefit, and that is when I will be paid. So it makes sense that I receive that benefit in my trust account, and I can deduct what's due to me and then pay you what's due to you as the client. But remember that Section 37A of the Pension Funds Act says that fund benefits are protected, and that has been interpreted to mean that we cannot make third-party payments, right? So a retirement fund can't make a third-party payment unless if the member or beneficiary proves that they cannot open a bank account. So some attorneys try to then argue and say that Section 37D4C, which I read out a few moments ago, the same section that says a non-member spouse is not a member or a beneficiary in relation to a fund. So some attorneys argue that that section specifically says that the non-member spouse is not a member or a beneficiary. Therefore, Section 37A, which talks about the protection of fund benefits, does not apply to the non-member spouse. So that means that you can make a third-party payment for this benefit that's due to the non-member spouse, right? But if you look at Section 7(8)(b) of the Divorce Act, you will see that it says that the same rules that apply to the member's benefit in terms of the protection of benefits also apply to the portion awarded to the non-member spouse. Now, that means that Section 37A of the Pension Funds Act applies to the portion awarded to the non-member spouse. And it is for that reason that we cannot make a third-party payment. If a member's employment is terminated before date of divorce, can the non-member spouse ask the fund to withhold payment until the divorce is finalized? The answer is no. The fund cannot withhold payment by its own accord. But if you do interdict the fund, then the fund would probably abide by that interdict. But please do bear in mind that in that case, the fund will still not be able to pay a claim for divorce benefits because the member would have exited before date of divorce. So if you interdict the fund with a view to find a different alternative, to make a plan to get the member to commit differently to pay that to the non-member spouse, then perhaps that can work for you. But do bear in mind that whatever happens, you will not be able to get payment directly from the fund itself. Can the fund give effect to an order requiring that the pension interest be calculated from date of marriage to date of divorce? Also something that we see quite often in practice, and the answer is no. So, and I understand that at times between the parties, you have that negotiation, that mediation, and the parties could come to an agreement to say that perhaps the one party is saying that we were only married for a short period of time. I have been a member of this fund for decades. Therefore, I feel that I should only give you a small portion of my pension interest and not the full 50%, right? And the other party could be in agreement and feel that that's only fair, and the parties could end up in a position where they both agree that the pension interest must be calculated from the date of marriage to date of divorce. However, going back to that definition of pension interest, it is contemplating only one point in time for the fund to calculate what is due, because it says it's the benefit that the member would have received had he resigned on the date of divorce. So the fund can only look at the date of divorce to determine what would have been the withdrawal benefit due to this member on that date. So the definition doesn't give you a start and an end date. It contemplates that the start date is the date that the member joined the fund, and you calculate from that date to date of divorce. So if the court order says, if the divorce order says, instead of calculating from date of inception of membership, you must calculate from date of marriage, then that, approach or interpretation would be inconsistent with the definition of pension interest in Section 1 of the Pension Funds Act. In fact, there was a matter decided by the Pension Funds Adjudicator somewhere in the mid-2010s in the matter of PAHO versus Sentinel Retirement Fund, where the adjudicator held that an interpretation of pension interest or calculation of pension interest from date of marriage to date of divorce is inconsistent with the definition of pension interest in Section 1 of the Divorce Act. So that would then render the court order, the divorce order, unenforceable against the fund. Remember that if ever there's a conflict between an order of court and legislation, then legislation prevails, right? Unless if the court order is an order made by a superior court and it's an order that declares that legislation inconsistent with the Constitution. And so that's the only exception where a court order would prevail over legislation. But in this case, even if it's a court order, it's a decree of divorce, it's saying we must calculate the pension interest from date of marriage to date of divorce, then it wouldn't prevail over legislation. Can the non-member spouse only be awarded 50% of the pension interest? So I've touched on that. The answer is no. There's nothing in law that regulates the portion that may be paid to a non-member spouse. It's entirely between the parties if they have a settlement agreement. Alternatively, it's up to the court if it's the court that makes a decision on the sharing of pension interest. If the divorce order is unenforceable against the fund, but the parties insist that the claim must be paid because it's an order of court, must the fund pay the claim? The answer is no, and we've touched on that to say that the fund will refuse to pay. What you do next will be up to you as the attorney representing the parties or representing the non-member spouse. But the fact that it's an order of court does not mean that it is fully compliant with the requirements. Remember the 5 requirements that we touched on, that the fund must be identifiable, must be named or identifiable, the portion awarded to the non-member spouse needs to be determinable, the member must be in active service if it's a pension or provident fund, the fund must be ordered to pay, and the order must refer to pension interest, nothing other than pension interest. So if that order does not satisfy these requirements, then it would be unenforceable against the fund, and the fund is not compelled to pay simply because this is an order of court. Can we apply for tax in the name of the member if the divorce order provides that we must do so? The answer is no, we cannot do that. Similar to that issue about interest that may be payable to the non-member spouse, this is something that is done by operation of law. So the Income Tax Act provides that the non-member spouse is responsible for tax. So when we pay that claim for divorce benefits, we apply for tax in the name of the non-member spouse, and that is something that is regulated by legislation in terms of the Income Tax Act. So you cannot, shift that tax liability from the non-member spouse to the member by court order. Again, to my point that if there's any conflict between legislation and an order of court, then legislation will prevail over that court order. What can a non-member spouse do with the pension interest awarded to him or her? He or her may receive the benefit as a lump sum directly in their bank account. If they cannot open a bank account, they will have to prove that to the satisfaction of the fund. And only once the fund is satisfied would the fund agree to make a third-party payment. Alternatively, the non-member spouse may transfer that pension interest to another retirement fund on their behalf. So either if they are themselves a member of a pension or provident fund or retirement annuity fund, or even transfer that money into a preservation fund. What happens if the order is enforceable but the non-member spouse does not claim it? So if the non-member spouse does not submit a court order to the fund in the first instance, if no court order is submitted to the fund, then the fund will not know that the member has been divorced and that there is this entitlement for the non-member spouse. So in the event that the member exits the fund will pay the member his or her full benefit. In the case where the divorce order is submitted to the fund, but then the fund decides that the order is enforceable, but the non-member spouse decides that he or she wants to abandon that claim. In that case, the fund cannot simply accept that instruction or request from the non-member spouse to say that they want to abandon their claim. And that is because, Section 37D of the Act sets out exactly what must happen in relation to a claim for divorce benefits. So the non-member spouse is not allowed to simply decide that they want to abandon the claim when the divorce order is enforceable against the fund. So if the non-member spouse does not submit claim forms, then the fund is required to keep that portion of the pension interest that was awarded to the non-member spouse until such time that they receive an instruction on how to pay that. Can a non-member spouse waive or renounce their claim? That's exactly what we just dealt with above. What happens if the non-member spouse dies before the fund pays the claim, then that claim becomes due to the non-member spouse's estate. If the divorce order is enforceable, then the benefit will be payable to the non-member spouse's estate. Can we pay pension interest to the liquidator of the divorced party's estate? We see that sometimes in practice, and the answer is no. Again, referring back to the fact that in terms of Section 37A, we cannot make third-party payments. We can only pay that directly to the non-member spouse or to another retirement fund on their behalf. The only exception where we would make a third-party payment is if we have received satisfactory proof that the non-member spouse cannot open a bank account. And when we speak about this issue of not being able to open a bank account, I have to say that, this is something that's still relatively new. I mean, the Pension Funds Act is 1956 legislation. It's quite old. But the amendment that allowed a fund to make a third-party payment as an exception where the member or beneficiary or non-member spouse cannot open a bank account is something that was only introduced in 2014. So there isn't any case law around that because it's still relatively new. Our view though, or let me say my view, is that the standard to be applied is that the person who says that they cannot open a bank account should not be referring to inability to opening a bank account due to convenience or inconvenience. So you can't say to me that, listen, the bank is too far. I live 100 kilometers away from a bank, therefore I cannot open a bank account. I don't believe that is an acceptable reason. I think we must consider the spirit of the legislation, and this particular subsection was intended to help those people where they could not get the IDs, or where the member or the beneficiary was an illegal immigrant and they just did not have an ID and could not open a bank account. So it has to be something that is a little extreme. I think, even physical disability, if someone were to prove that, the member or beneficiary cannot move, they need assistance with daily living activities due to disability, then we can accept that. But for someone who's able-bodied and simply not wanting to open a bank account because it's inconvenient for them, I don't think that would be an acceptable reason to apply the exception. And that brings us to the end of the presentation. Are there any questions at this point? Masika, I see your hand. Do you have a question?
My apologies. It's an old hand.
All right, so ladies and gentlemen, thank you for making the time to attend the presentation. I hope you found it insightful. I hope it adds some value to what you deal with on a daily basis, or as and when these pension matters come across your desk. This brings us to the end of day one of the presentation. I hope to see you again tomorrow morning at 10 o'clock, where we will start with day two of the pension law webinar. And tomorrow we will be looking into the distribution of death benefits payable by retirement funds. So thank you to everyone. Please enjoy the rest of your day.
Thanks, Andrew.
Thank you, Andrew.
Thank you.
Thank you.
Thank you. Bye.
Thank you.
Thank you.